titled International Law, International Relations, and the Rule of Law. Our moderator today is Mr. Thomas Durkin. He's with us today from Chicago. He's a world-renowned defense attorney and is pretty busy, so we're very happy that he could be with us today. He's going to be leading the discussion with our three panelists, and without further ado, here's Mr. Durkin.
I don't think I've ever been called, I've been called a lot of things in my career, but I don't think I've ever been called world-renowned. So, is there a video of this that I can I'm delighted to be here. I'm a graduate of, I'm a member of the 1968 undergraduate class at Notre Dame. And this is where my heart is. Even if the university sometimes these days doesn't quite follow where my heart would want it to go, it's still where my heart is. This is where I fell in love with the Catholic social justice mission of a bunch of young Holy Cross priests, most of whom are now dead, which has not escaped my attention in terms of my age. So I'm delighted to be here. And I've also was delighted by both of the panel and the debate today. I think this is exactly the kind of discussion Notre Dame should be having. I thought the debate brought out the real heart of what I think Notre Dame is all about. My heart is absolutely with Mary Ellen from my days in 1968. My head, on the other hand, is much more with John Mearsheimer, which points the problem out. And it's a problem that I encounter in our domestic terrorism cases that we're defending today. It's what I encountered in Guantanamo, in both the detainee cases we've handled and are still handling with a forever prisoner, and with the 9/11 case that I was involved in the military commissions. And I think this panel is going to get there, and I think one of the issues that's going to jump off the page, or at least has jumped off the page to me, is that from the first discussion this morning, we heard a lot about sovereignty. And really at the heart of the debate between Mary Ellen and John is also a question of sovereignty. And it takes me back to my favorite political theory discussion with respect to the war on terror is something called the state of exception, or the state of emergency. John mentioned the legality that Hitler relied on, or the Third Reich relied on, which is absolutely true, which brings in the question of, are we operating in a rule of law, or are we operating under a rule by law? And I think Karen is going to get, our first speaker, Karen Greenberg from the Fordham National Security Center, is going to get to that. The state of exception goes back to Carl Schmitt. In the first sentence of his political theory book, Political Theology, says, sovereign is he who makes the exception. And I think if you could condense everything we've discussed today, that's what we're talking about. Who gets to make the exception? Or, a better question posed by an Italian philosopher of some repute by the name of Giorgio Agamben, do we have a permanent state of exception in Western rule of law? And I think the other two speakers, which we're delighted to have, Brad Roth from Wayne State and Vasuki Nesiah from NYU, are going to follow up on a more populist, practical explanation of where we've gotten with respect to international law and the rule of law. So with that, my friend Karen Greenberg, who came all the way from New York. So very far away.
Thanks.
More ways than one.
Yeah, okay, I'm not going there. Thank you, Tom. Thank you, Mary Ellen. I'm really happy to be here. And I just want to tell you guys how lucky you are, because I think there are a lot of rooms I'm in these days, because I go and I eavesdrop on very powerful policy conversations about very knowledgeable people, and they don't have this discussion, and they should. So maybe you should export this idea And it's a very important discussion. I am not an expert in international law, so I don't want to disappoint you. I want to tell you at the beginning, I will not be speaking about international law per se, but I'm going to kind of tell you why I think international law is important to where this country is today. So first I want to tell you something that kind of ties into the sovereignty question and to remarks you've heard earlier. It's kind of a joke, but it's not funny, which is that when a number of the regulations were being decided after the attacks of 9/11, there was a heated debate going on the floor of the Congress. And one of the lawyers on the floor, who was a congressperson, inappropriately used the term stare decisis. Doesn't sound like it should bother anybody. And the amount of condemnation that came down on him for using this term because it showed that he didn't respect the sovereignty of the United States for using a foreign concept. And let me tell you, right, thank you. And when I was like, okay, we're done. So what I want to talk about today is much of what I see has happened that's brought the United States to where it is today started at 9/11, and it started very much in the claim to a state of exception and a state of emergency. Not exactly what Tom was talking about, but springing off of that. And although domestic law, starting with the Patriot Act, which was passed in the fall of 2001, and I'm going to come back to that at the very end today, was extremely important, I want to argue that it was the breaking of international law at the get-go and the treating of international discussions at the get-go that served as the threshold or the doorway to allowing the United States to incrementally and now for 18 years compromise laws, regulations, customs, and the public space surrounding the rule of law. So I'm not going to tell you all of that today, but I'm going to tell you a little bit about it. And I will start with something you probably know about, but just in case you don't. As you know, there were a number of legal memos that were written in the fall of 2001 and the spring and summer of 2002. The bulk of those memos set a path to separating the United States from a number of rules and regulations regarding detention and interrogation. And if you look at those memos, they are very clear about what the framework of law they want to use is. As they said at the time, and as it's in protest, and as it's said now, it was more like outer space than anything else. But as one lawyer in the Justice Department said at the time, we have laws for outer space. In January of 2002, the White House counsel, Alberto Gonzales, White House counsel at the time, later Attorney General, used two words to describe what he thought the legal framework should and shouldn't be for the war on terror. And those words, which have, are repeated over and over, were that in reference to the Geneva Conventions, that they were quaint and obsolete. And he was talking specifically about Geneva Convention 3, which is about the protection of prisoners of war, protections due to prisoners of war. But he meant much more than that. And he was not unthinking about talking about international law and not domestic law, because actually, if you're going to talk about detention and you're going to talk about a military base that is, within U.S. Custody, then you also have to talk about domestic law or military law, and he did not want to do that. And what he basically said was, look, we're done with this international order. It doesn't apply to us. We were attacked. Go away. We're happy to help you when we're in good standing with ourselves, when we feel peaceful, when we feel safe, but we're not going to go there. So number one thing, understand this is quaint and obsolete. And John Yoo, who was a lawyer in the Office of Legal Counsel at the time that wrote the memos that convinced Alberto Gonzales and others that we should step away from the country should step away from a number of legal frameworks, military, domestic, and international, later wrote about this, and he said, it was very clear to us that the last thing in the world we needed after 9/11 was have to adhere to international law. All that mattered was that we stayed safe. So it wasn't that this was something that happened under the table. It wasn't something that happened unconsciously. It wasn't something that just happened because it was necessary for the moment. these were people who wanted a move away from international law anyway. This was not their first iteration about the way in which international law was an obstacle to what they wanted to do domestically. This had been a long-term meme that had been running through a variety of legal opinions, organizations, mostly the Federalist Society, and it sort of saw its chance in 9/11, and this memo of January 2002 sort of gave it the language that it needed. So while you might think that we just step aside from it, it won't be important, let me tell you what came out of the decision to push aside international law, and in particular Geneva III, and how important that is to where we are today. And I want to make sure I stay in my time. So the first thing is that this is, of course, the basis for Guantanamo, right? So we step aside from international law in order to create Guantanamo. It's a law-free space. It's beholden to no rules. How do we know that? And this is really what I want to talk about. The things that came out of the step away from international law were the things that we've used in other ways. The first thing was to get rid of the language. No longer were we going to use the language of international law. So one word that you were not going to use, or one set of words you weren't going to use, was prisoner of war. From the Pentagon, the directive came down, don't use it. It's not, if you use it, then you will invoke international law. We mean it when we say we're stepping away from it. You can try to adhere to it until we make up a policy, but do not use the word prisoner or prisoner of war, because then it will invoke all of these. And so we created the word detainee. Now, we didn't create it, but we decided to use it for our detainees in the war on terror. A second thing was secrecy. It's one thing to have secrets because of a state of exception. It's one thing to have secrets because of a state of emergency. The way the detention policy was laid out at Guantanamo was explicitly and determinedly in secret. The memos were secret, the policy was secret, and it was secret to the international community as well as the domestic community. And it became a way of saying, look, this is our first codified policy. Yes, we have the Patriot Act, but it's going to take a long time for us to develop the programs we want to develop out of the Patriot Act. This is what we have now. This is our biggest endeavor now. And as we know, it led to torture, which I don't think I'll have time to get to. But this is another framework for how we're going to set this up. Third thing, in removing the idea of prisoners of war, they didn't just take away the idea of international law. They took away the idea of law at all. Because once you change the words, there was no category for these human beings to be in. So here they are at Guantanamo without any, we called them, we kept making up new names, you know, enemy combatant, then we might get in trouble, they might be lawful enemy combatants, then they were unlawful enemy combatants. We had so many different names for them, but none that actually suggested a legal category that they belonged to. And the loss of a legal category was the loss of a certain aspect of being a human being on the earth that they have still not recovered to this day. They are still detainees in a lawless space without any, especially the ones that aren't being tried by military commission, without any legal definitional place. And this is not a minor thing to mention, because I want to just skip ahead to today. One of the things that was said repeatedly in district courts, in circuit courts, in the Supreme Court was, what's wrong with what we've done in stepping away from international law, doing it secretly, and a lot of it was guesswork at the time by attorneys, creating a new category for these individuals, creating a new language around them, and putting them in a lawless zone. One of the consequences of this is it's going to bleed into the domestic space. And even, you know, what we would call your liberal-minded professors and legal minds and politicians were like, that's not going to happen. This is the war on terror. One of the things that George Bush and President Obama wanted to do and made very explicit was, we're going to take the war over there. We're going to take it and its problems and everything else over there. And you know what? Guantanamo's over there. It may be fast enough that we can get there on a plane if we want to, but it's over there. But a lot of critics said at the time, don't do this because it's going to come here. Not because we respect these people, they should have human rights, all of that. It was that we respect these people, they should have human rights because these human rights and civil liberties could be taken away from people in our custody on our shore. And in a lot of the cases that Tom has had to litigate over the years, and I don't know how many that is, but there have been over 600, and he's had a fair share of them, either directly or indirectly advising. What we have seen are small, Tom's going to disagree, but are small ways in which the law has been changed in order to deal with our detainees at home.
I don't disagree at all.
Okay. I thought you were going to disagree with small.
Oh.
Yeah, okay. Right. So what I meant, okay, and I kind of disagree too, but what I meant was incremental so that nobody really noticed the policy that was happening. So you could stay in custody without a lawyer, without being Mirandized. You could stay in custody for longer periods of time than before based on national security concerns. You could have evidence not be able to be presented in court based on national security concerns, and Tom would be much better at this maybe, but I told Mary Ellen to let him do this instead, but anyway. But you could see this withering away of the ability of the legal system to protect those who were defendants in criminal court. And for 18 years, we've been watching this happening. But that is actually not where this policy went. It's going there. But the other place this policy went was the border. And now you're seeing it here at the border, in this country, not here in Indiana. You're seeing it at our border. If you don't think there's a relationship between what happened at the border and what's happening at the border and what's happening in Guantanamo, you need to think again. You need to understand that it came out of the Department of Homeland Security, that the Department of Homeland Security was run by John Kelly, who ran Guantanamo. You need to know that this idea of detaining people indefinitely, without a lawyer, without due process, without trial, without anything, without charge, has been in the works now in the United States for enough period of time that it is not a state of exception, it is a state of permanence. And the fact that they've gotten away with detaining women, children, men, I love that women and children are more important than men, but women, children, and men, but they are in some ways children, is actually a riff on what happened at Guantanamo. And the reason I wanted to point that out to you is that this is tied up to much larger concerns, one of which I wasn't here for the morning, but one of the issues I think really needs to be discussed within the context of international law, and I've been working on a project on this at the Century Foundation, is the issue of citizenship. What is happening to citizenship in the wake of things like Guantanamo, in which basically stateless persons were, declared to be stateless because of the countries they came from, didn't really have a citizenship. That's why the Yemenis have spent so long at Guantanamo. And the way in which rights, once they're taken away from people on the far edges over there in our minds, incrementally creep into us. And so I wanted to just spend my last couple minutes talking about the erosion of citizenship in this country, something that began on 9/11 here with the roundup in Muslim Americans right after 9/11, and that has perpetuated itself not just at the border, not just through our terrorism cases, but in a variety of ways. And I wanted to focus on one case, because there is one case right now that is extremely interesting in this regard. And that is the case of Adnan Hassoun. Has anyone heard of this case? This is interesting, right? Do you know this case? Yeah. So this is a young, well, he's not a young man. This was a male who was born in Lebanon, came to the United States in 1989, and gave money during the 90s to a number of causes in Bosnia that were a variety of things. We don't really know. A lot of these documents we haven't seen. He was arrested and later convicted of providing material support to those this is a post 9/11 case about something that happened in the 90s. Arrested, convicted of material support, which is the major charge that is held against terrorists, very successfully, very broadly. At the time, he had a graduate degree, he had 3 children, he was not a citizen, he was a resident. He became part of a larger case in which the other people in it had more evidence against them, I think. He was, the government wanted life. He got 15 years. His 15 years have been up for a long time. And our government had, I think, 3 years, actually. He would have gotten out with that extra, but now I'm not sure exactly what the period of time is. But the government has decided they're not going to let him go. The most interesting thing is what they're using legally to detain him. The law they're using legally to detain him is the Patriot Act, in a clause that was never used before this. And so what you see is a way in which this is my brain, in a way in which an exception that was made for under international law definitions, processes, humans that we wanted to separate from international law, had a little bit of a wedge inside the American statute, and is now being used in the way that the Guantanamo paradigm was set up. The reason they won't let this man go is that they think that he's Palestinian and therefore stateless. And so it's the exact same reasons they don't want people to go out of Guantanamo. The reason of where will they go if they don't have a state affiliation and more. It is also the same reason you're seeing refugees around the world held in camps in detention, not necessarily criminalized. And so this case is now coming to the fore. There are a number of law schools that have signed on to it. Not Notre Dame yet, but anyway, I'm just saying, University of Chicago is one, Buffalo is one. And they're going to litigate this case and try to get this man released. But if he doesn't get released, what this country has got to understand is that we now have a system of indefinite detention. We have created it at the border. We created a Guantanamo. We have let it spread to the border. We've let it spread to terrorism cases, and now there's all talk about not letting people who have served their term, criminal terms, in jail out. The same way the Brits are now talking about doing it and actually doing it. And we see it in a couple other places, like the detention of drug smugglers on boats. So really what I want to say is don't break it, because when you break it, you can't fix it. And I was really struck by the conversation preceding this one about, here's the ideal world, here's the way in which it may or may not play out. I have a feeling that it hasn't quite dawned on Americans yet how broken what we thought we had as protections are. And so I want to just end with this one final thought. One of the things that you always read about in the papers and you hear these pundits talk about is that, the real bad thing is that, the United States isn't a beacon for the world anymore in human rights and international law. It's true. That actually is one of the greatest consequences of the policy of the war on terror that's been allowed to stay until this day, and to morph and to change and to turn back on ourselves what we thought we were turning onto the world. The fact is that without the United States and its buy-in into these codes that are both domestic and internationally agreed upon, there is kind of a Wild West out there and a free-for-all. So I want to say something really positive at the end, but especially after Mary Ellen's thing, which was scary. But I think we're in bad shape, and so I'm going to leave it to the international law experts to fix it.
Well, thank you very much. You're missing the impeachment discussion, so I know there's got to be something in it for you to be here for this. So I'll try to live up to that. And I particularly want to thank my very close colleague, Professor Mary Ellen O'Connell, who was generous enough to invite me here, and who has really been a pillar in this field of kind of moral gravity of the issues that we face here. I think no one has really stood up often against remarkable array of opposition to stand for values of peace and the rule of law. There's so many things that I want to react to that have occurred in the course of the day. I almost want to just make a list of all of those and speak to each of them, but rather I'll try to weave these things together into the discussion that I had planned, which is based on a paper called Legitimacy in the International Order, the Continuing Relevance of Sovereign States. What it really is, in a sense, at one level, is something we haven't heard yet today in any systematic way, which is a defense of international legal positivism. There are various paradoxes about this. Well, the first paradox is that I don't regard myself as a positivist in any real sense. I actually am a critic of positivism as a matter of legal philosophy. I think it fundamentally misunderstands the project of law in certain ways. However, I embrace all the things about positivism that people don't like, generally speaking, and therefore I'm going to make a defense of it because I think that it's important to recognize that there is something significant about the project of positive law, which relates to some of the things that we've talked about earlier in the day. So first of all, I want to say something about Thomas Hobbes. I teach Thomas Hobbes, and he's gotten kind of rough treatment here today. There are some things about Hobbes that are a lot more subtle than people realize. First of all, very important to recognize something that he says about compliance with rules where there isn't a problem of anticipating non-compliance by others. There's a sort of general problem, structural problem of anarchy that Professor Mearsheimer talks about, but where the other side has complied or where there's a guarantee of the other side of complying, then the person who seeks to not comply, who seeks to have his cake and eat it too, to get the deal and to cheat on it, is the fool. And there's something really important about that. The fool is someone who no one's going to trust down the line. The fool is going to pay a price for having taken that position. And so it is true, as has been mentioned by Christina Cerna and others today, invoking my old mentor, Louis Henkin, that almost all states obey almost all international laws almost all the time. The almost, of course, is something that Professor Mearsheimer can exploit as a loophole in all of this in a very significant way. But it's very important to recognize that for most states in most circumstances, the cost of getting your own way in a particular instance is too high to pay where you're breaching the terms of accommodation that make possible systematic address of the kinds of issues that you face. And so there, with respect to broad swaths of the law, including many aspects of law that pertain to matters at the core of states' interests, not just the ones at the periphery of states' interests, it actually turns out to be very important that states, as a practical matter, maintain faith with international legal regimes. And it's true that you can sometimes breach these things and get away with it. Words of the wise, if you're going to breach it, you might get away with it if you win. But what happens when you breach it and you lose? What happens when it goes bad on you? Then who do you turn to bail you out of that situation? What sort of price do you pay then? You might get away with it if things turn your way. If things turn the other way, not so much. And I think we have paid a big price for Iraq and for other breaches of international law. Another thing about Hobbes is important to recognize. The crucial thing about Hobbes is the structure of the situation that he talks about in The State of Nature. And the structure of that situation has implications not just for people who are selfish and grasping and have all of these sort of qualities that are stereotypically associated with Hobbes. You could be an altruist. Indeed, according to my mentor, Jeremy Waldron, who did a wonderful piece combining Hobbes and Kant on this very topic, moral vehemence is every bit as much a source of conflict and deadly conflict as selfishness. Indeed, sometimes more so. And so the requirement to have an effective system of positive law in order to achieve fundamental purposes of peace and cooperation is not simply a hedge against selfishness and graspingness and and vaingloriousness and all of these things that people cite out of Hobbes. It is also the need to have a hedge against empowered righteousness. It is that if people are left to their own devices to pursue what they consider to be a moral imperative in their own unilateral determination, what you're going to get is conflict, and particularly what you're going to get in conflict in the international system is sort of righteousness as perceived by the strong. And so there are important moral imperatives to a regime of positive law in the international system that I think easily get slighted. There are moral purposes that are embedded in this process of international lawmaking. And what I want to argue for is the idea that there are what are sometimes called content-independent moral reasons to comply with law because it's law. That means that there's a presumption in favor of applying and complying with existing international law as it's been made through customary practice and through treaties. The need to do this, of course, often confronts other kinds of moral imperatives. And it doesn't necessarily hold up to say that these content-independent moral reasons to obey the law trump every other kind of consideration. There are going to be countervailing considerations that have to be weighed in individual cases. But people greatly understate the significance of the kinds of norms that we're talking about here. There's a lot that was said in the morning panel about human rights, and ordinarily what one says about these kinds of things is, well, I agree with you in the abstract, I just disagree with the details. I want to say the opposite, that I agree with the details, I disagree with the abstractions. It's often said in law schools like this that hard cases make bad law. I don't actually think that's true. I do think that extreme cases generate bad dicta, that there's a tendency to try to make generalizations out of particular circumstances where you overstate, in fact, what you need to resolve the particular case, to add a kind of rhetorical flourish that moralizes the project in some broad way that ends up actually obliterating legal constraint in other circumstances. And so there is this tendency to make appeals, I think, unnecessarily to conceptions of natural justice that then have the effect of licensing people to pursue their own particular conception of morality, even where it can have very unfortunate results. It's no discussion of any of these things is ever complete without having reference back to John Yoo, because I used to know John before we stopped talking to each other. I actually, the end of our relationship came in an email exchange about the memos where I quoted back to him his language, and I tried to get to the bottom of his methodological basis for taking the position that he did, and I clearly, he understood the conclusion I came to and cut off the discussion at a certain point. I came to the conclusion he actually didn't have any methodological foundation to what he was doing. The most important critique of what people like John Yoo did in the global war on terrorism was that they violated methodological principles with respect to both international and domestic law. It's true, as John Mearsheimer says, that yeah, you can make anything up, you can hire somebody who will make any argument you want. But there is actually a methodological core. There are things that people disagree about within a certain scope, but there are certain arguments that don't make any sense, no matter how you dress them up, and certain propositions that are untenable as well as being evil. I want to bracket the question of how evil it is, because if you fixate on the evil of it, it will just sound like your opinion about how to weigh the various grave matters of, on the one hand, human rights and humanitarian law, and on the other hand, national security threats and so forth. The fact is that the United States was committed to a series of standards established in treaty law and established in customary law that absolutely prohibited the things that were being done there. And it lets John off easy to divert the discussion into perennial questions about the relationship between positive law and natural law. That's not where the action is here, and that's not where the breaches of professional responsibility are here. And so that's something to pay attention to. The other thing that I want to fixate on here is that international legal positivism is necessarily predicated on states as the primary movers of international law, and so we have to deal with the question of sovereignty. And the term sovereignty gets kicked around a lot. And part of the problem with it is the fundamental ambiguity of the term. It's not just that there are different conceptions of sovereignty, it's that there are different concepts of sovereignty that have a certain kind of overlap, but they're actually part of entirely different conversations. They relate to one another in a certain way, but they're not at all the same. So one kind of sovereignty discussion is a discussion about the effective independence of state actors, their ability to unilaterally control certain circumstances or at least to unilaterally set their own policies with respect to those circumstances. And that is an empirical matter that waxes and wanes over time, potentially. Some would say that there never was any such thing as sovereignty. Whatever the case may be, this is a variable empirical matter. As long as states retain some capacity, it becomes a relevant question. Then there's the sovereignty as a policy matter, best exemplified by the brilliant words of Dominic Cummings. People know who he is? This is Boris Johnson Svengali. Boris Johnson has a wonderful ability to project his ideas through three-word phrases that are concocted by Dominic Cummings. Take back control is the crucial term used by Dominic Cummings, that before get Brexit done and all that sort of thing, loads of these three-word phrases. But take back control corresponds to a really significant impulse that people have with respect to the international legal order. You can argue that it's folly to take back control, and that indeed that Brexit was folly, but it's important to recognize the significance of the impulse and the sense of loss of control that is driving the undermining of legitimacy of international institutions and of international law itself. And if we're not attentive to that, we're going to have a big problem, but a little more on that later. In any event, sovereignty as a policy concern to maintain or enhance one's capacity to do this is a whole question unto itself. Sovereignty within law is a different thing, and there's sovereignty within domestic law and there's sovereignty within international law. The relevance of sovereignty to domestic law is kind of counterintuitive. We think in a rule of law society of sovereignty as being constituted by legal rules. That's the whole project of liberal public law, that we're going to make everyone accountable, that the exercise of power is always going to be bridled by rules, and the combination of different actors operating within their legal competences will generate collectively what ultimately is the sovereign decision. But that brings us to our old friend Carl Schmitt, who pointed out something that really was not novel to Carl Schmitt. It was something that was understood by John Locke in Chapter 14 of the Second Treatise of Government. It was something understood by Abraham Lincoln in what I call the All the Laws But One speech when he rationalized the suspension of habeas corpus. It's the idea that there are circumstances in which the threat to the very order that makes law possible is such that in order to save that order, you have to actually suspend compliance with those terms. Justice Jackson famously talked about how the Constitution is not a suicide pact. And he said more concrete things than that. If you ever actually read his dissent in Korematsu versus United States, it is a remarkable document that most people have not read carefully. It's a very Schmittian document, in fact, even though he comes down against the government ultimately in that decision. So you have this residual idea of sovereignty that exists notwithstanding the constitutive norms of a legal order. Again, Schmidt simply identified the fact that sovereign is he who decides on the exception. So sovereignty maintains a certain kind of significance in domestic law, and it has a kind of counterpart in international law because of the relationship between international and domestic authority. That international and domestic authority are not one seamless web. The international legal order is not a legal order of legal orders. It's a legal order of sovereign political communities, and those sovereign political communities have the authority, even though not the right, to breach their international legal obligations. If you study U.S. foreign relations law, you know this very well, because the first lie we tell everybody is the line from Paquete Habana that international law is part of our law. Well, not so much. Because there's such a thing as a controlling executive act, which has been terribly abused. That's not what the court meant in Paquete Habana at all, but it ended up being used in a particular way. We have all sorts of ways in which we have firewalls between international law and domestic legal authority. So this is one of the aspects of the ways in which sovereignty actually operates within the international legal order as it is. And international law sometimes has to accommodate the fact that legal facts can be generated by exercises of authority by states that are in breach of their international legal obligations. It's a much more complex interaction than we might imagine from something analogous to the supremacy clause of the US Constitution governing the relationship between federal and state authority. The other key aspects, of course, of sovereignty within international law have to do with ideas about consent, and I couldn't possibly belabor the nature of international legal methodology here, just to say that one needs to tread lightly on the question of jus cogens, in part because it's difficult to identify what the source of jus cogens is. Even more importantly, though, difficult to identify what the actual legal effects of jus cogens norms are. And great overstatements take place in that regard. The international legal order is basically an order that is formed by the will of states in one way or other, not necessarily consent, most straightforwardly understood. And that legal order also makes it difficult to vindicate particular established international legal norms because there are firewalls within international law. Self-help is disfavored. Countermeasures are strictly limited. Countermeasures are available to the strong, they're not available to the weak. And for that reason, they are bridled. There are reasons for a norm against intervention in the internal affairs of states. There are reasons why the use of force across borders, even in circumstances where some morally compelling outcome is sought, is extremely problematic from the standpoint of positive international law. And these things have to be respected. This is sovereignty within international law. And the argument that I ultimately want to make is that if we don't acknowledge the significance of sovereignty within international law, we are going to open the door to people who want to talk about sovereignty against international law. That they are going to imagine that if they're bound to an international legal order, that's the end of their self-determination, that whatever it's going to be a bait and switch game. They're going to have agreed to a treaty that says one thing, and then natural law-oriented jurists are going to take them to a place they never imagined. There is going to be an enhancement of the kind of resentment that we have seen building up in various parts of the world, where the idea is that there's no control, that you have basically the denuding of the idea of democracy. We can't figure out what there is left to be democratic about. We have, on the one hand, technocratic solutions beyond the reach of ordinary individuals, and on the other hand, judicial decisions that seem to take away from elected representatives the ability to make decisions that have to do with fundamental matters of political morality. And so what is left to us as citizens? What is the stuff of our political membership? And so the urge then naturally is to take back control, And in some ways, it is a healthy impulse. And unfortunately, that healthy impulse can be perverted in such a way as to lead us to very, very dark places. So I will leave you with that. Thanks.
I think I've failed as a moderator to monitor the time, but Suzuki, you feel free to go as long as you need.
Okay.
If anyone I just thought that was fascinating, so I didn't want to interrupt. But if anybody has to leave at 3, I think we go to 3, Bailey. Oh, 3. Oh, 3. Well, we got plenty of time. Never mind. I spoke too soon. Take all the time you want. Yeah.
Such a dangerous invitation. Thank you so much to Mary Ellen for inviting me, to Tom, my fellow panelists, and of course all the student organizers who have been so central to this the symposium. As many of our speakers have discussed today, there is a legitimacy crisis in international law. In response, in the face of revived and reinvigorated strands of authoritarianism, the temptation is often to embrace international law and a highlighting of its liberal legacies, the ways in which international institutions have been seen as champions of the rule of law in its most high-minded manifestation. I argue instead that rather than redeem international law, we need to see the crisis as an opportunity to interrogate the dark side of international law, including and perhaps especially its intimate imbrications with histories of racial capitalism over the last 400 years. Rather than focus only on international law and its story of the abolition of the slave trade, for instance, we need to also look at international law's history facilitating slavery and racial oppression. Rather than focus only on international law and its story of decolonization, we need to also look at international law's history facilitating colonial and neocolonial oppression. So in my presentation today, I draw on my past work on the history of international criminal law to offer 2 examples of this redemptive turn to history by noted scholars of international law and international relations. One from the mid-19th century and one from the mid-20th century. So in contrast to the other presenters, I'm going to go back in history a little bit. And then I proceed to tell a counter history of those same moments. So I give you 2 examples of liberal redemption in some sense and a critique of both of those. So the 2 histories that I present as my foils are by a legal scholar and a political scientist, both responding to the politics of impunity and its institutional channeling into international criminal law. The first case I look at is by Jennifer Martinez, the dean of Stanford Law School, and her account of the mid-19th century tribunals that were instituted on diverse shores of the Atlantic Ocean to monitor the abolishing of the slave trade from 1807 on. For Martinez, this is inspiration for a future of international criminal law that can deal with race and racial justice. The second case I look at is Gary Bass's account of Nuremberg and his history of international criminal justice, so 100 years later, as an alternative to vengeance in the fight against impunity. For Bass, this is inspiration for a future of international criminal law that can entrench the rule of law and a normatively grounded world order. For both of them, these institutions were exemplars of morality marrying power. These are both interesting histories, and there is comfort in their re-embrace of liberalism and the rule of law. However, I argue that their turn towards histories of and for disciplinary redemption warrant critical interrogation. So let me begin with the Martinez story. So Martinez's book is published in 2012, a decade into the life of the International Criminal Court, when it was seen on the one hand as often by critics, on the one hand, as often irrelevant from Syria to Iraq. We have seen a dramatic escalation of the very atrocities that the ICC's mandate seeks to address without success. At the same time, the ICC had also been immersed by that time in deep controversy over the impunity of countries like the US and Russia, while it had an Africa-focused docket that raised specters of racism and neocolonialism. Written while the ICC's legitimacy crisis was brewing, Jenny Martinez's story says these mid-19th century tribunals could function as a bridge to the future. That's her term, bridge to the future, and a more hopeful lesson about the potential of international courts for us today. In her telling, that is a bridge constructed by judicious institutional purpose in the name of race-neutral humanity. However, in this presentation, I want to argue that there are racialized girders that hold up this bridge, girders that are not visible unless we peer under the bridge and dig around the foundation of its institutional legacy. Martinez is especially interested in the 19th century mixed tribunals that were established on both sides of the Atlantic to implement the abolition of the slave trade, instituted under Anglo-European and Anglo-American political, legal, and military authority on territories that had been colonized on both sides of the Atlantic. So places like Sierra Leone, Cuba, Suriname, Brazil, these all had these tribunals that were constituted by treaties, and that Martinez sees as sort of the beginning of human rights and as sort of the precursor to the ICC. Thus, the Atlantic Ocean was carved up as a racialized structure of world order even before Europe carved up the African continent at the infamous 1884 Berlin Conference. What is striking, however, that these commissions did not invoke race, and they're celebrated instead as institutions that fought racial oppression of the international slave trade. In her path-breaking 1993 essay, Whiteness as Property, Cheryl Harris describes how the project of racialization was not only about identity and affiliation, but also fundamentally a project of stealth material distribution. Whiteness as property, Harris argues, has carried and produced a heavy legacy. It is a ghost that haunted the political and legal domains, only rarely declaring its presence. The struggle against structural racism has entailed remembering, naming, and rendering visible the work of racial architectures and ideologies, understanding the mechanics of invisibility and exposing how, in fact, race drives the plot. In this case, it is about foregrounding how racial capitalism, including the specific contours of slavery and empire, was central to the structures and ideologies of the 17th and 18th century world order that led up to the mixed commissions. The story of the mixed commissions is not a heroic story of overcoming racial oppression, but I argue it's about the stealth inauguration of a new racial ordering, moving from mercantile economies to the world of free trade as a machinery of that racial ordering, from slavery to indenture, from slavery to colonialism. Indeed, many of those who bankrolled and supported abolition were those who had investments in the colonization societies, people like Josiah Wedgwood, sort of the capitalists of the period in England, and heralded the profit to the plantation economy. This is sort of central, for instance, to what people like William Wilberforce argued in arguing for abolition, that if slavery was a domestic enterprise rather than one fed by the international slave trade, the Caribbean plantations would thrive and would go from profit to profit. The erasure of race and racialized power from ICL history, for intercriminal law history, is partly affected by translating questions regarding the racial ordering of the Atlantic world into legal questions. Law and legal institutions translated the politics of race into technical legal questions regarding nationality and jurisdiction, property and prize law, legal personhood, and juridical freedom. Race is rendered invisible even in legal principles, such as abolition, that purport to hold race to account. As Richard Delgado and John Stefanik have noted in their discussion of American jurisprudence, the very language of law carries with it a canonical interpretation predicated on silencing questions of race and power. The law does have a canon, they argued. It consists of terms like just, fair, equal, etc., all with canonical meanings that reflect our sense of how things ought to be, namely much as they are. Racialized structures and imaginaries hide, in other words, in plain sight, in histories of these tribunals as an embryonic ICL, present everywhere, yet not acknowledged anywhere. During the course of their existence, the British-operated Sierra Leone courts judged that 65,000 captured men and women should be freed because they were being illegally trafficked in the courts. The courts in Havana, Rio, and elsewhere released another 15,000 Africans. The men and women who had been captured aboard these ships hailed from across the African continent. It is significant, however, that the courts ordered their release but imposed no further responsibility on the slavers to ensure that they were able to go home. Thus, in the majority of cases, the freed found themselves in hundreds or thousands of miles from home in an environment where they did not speak the local language and did not have the resources or geographic knowledge to return to their families. By mid-century, Freetown in Sierra Leone had over 40,000 people from across the continent who spoke over 100 languages. Thus, we see very concretely the production of the freed slave as legal persons without race, history, and social context. Their humanity is reduced to their legal status and detached from their community. Not a counter to the dehumanization of slave relations, juridical freedom carried its own oppressive pathologies and justifies its own unfreedoms, but this time internal to the ostensibly colorblind notion of the human. In reading race and its erasures into that story, we get a very different narrative about how Euro-America empowered itself for and through imperial conquest in the wake of the slave trade. And this empowerment worked partly by constructing a category of whiteness and by mirrored necessity a racial other. Yet it is not whiteness that heralds its own presence. Rather, it is a whiteness that presents as nothing less than the New World Order. Here, latent in the cosmopolitan institutionalism that seeks to knit together humanitarian aims with international adjudication. However, foregrounding racial capitalism in both its material and ideational dimensions opens a window into the work of the colorblind law of the human in putting wind in the sails of a racially maldistributive regime of global governance to travel under color of law. The mandate and role of the mixed commissions is the implementation of the abolishing of the slave trade through canonical legal terms in the global racial ordering of the day: treaty, jurisdiction, prize law, property, persons. These terms work to steer our gaze away from the entanglements of freedom and slavery to instead focus on juridically recognized perpetrators and the drama of the slave trader as moral and legal outliers. The slave trader emerges as an exceptional perpetrator whose most remarkable and enabling characteristic is not his location in the racialized logics of profit and property that sustain the majority of humanity's profiteers, but his moral pathology and legal guilt. This denial of the entanglement of slavery and freedom empowers liberal juridification and equates racial consciousness with the illiberal and inhumane profiting from racial distinction. Then the slave trader, in contemporary international criminal law, it is a genocidaire and the war criminal. In this way, the racial cleansing of that heritage of the human as race-neutral rule of law remains forever entangled with law, defining and prosecuting the inhuman. In understanding the imbrication of the field of ICL history in that ideological work, we need to confront the challenge that the most shocking fact about the international slave trade was not a rare inhuman monstrosity, but, channeling Arendt, but a banal human ordinariness. In refusing to confront what has been called the dark side of human virtue, the redemptive history of the notion of crimes against humanity renders the victim abstract, deracialized, universal. Today we may say it is a category that stands for the problematic rallying cry that all lives matter. This is an indictment of international law, not its redemption. Okay, let me switch to my second story, that's Nuremberg. In Stay the Hand of Vengeance, the politics of war crimes tribunals, Gary Bass seeks to interpret war crimes tribunals and efforts towards such tribunals as a struggle for humanist idealism in international relations. So there's some relationship, I think, to our debate just now. And he claims a close nexus between these initiatives and liberal states. There are two struggles in Bass's account: an internal struggle with the liberal states for the better angels to triumph over Kissingerian realists, and an external struggle with illiberal states. For Bass, this is a story of fitful progress towards the rule of law and its redemption. Nuremberg looms large in the history of anti-impunity efforts. The trials are presented as performatively enacting the Allies' moral authority in the defeat of fascism. For Bass, the shift from executions to trials is a shift from vengeance to liberal legalism that pulls the aftermath of World War II into the human rights history books of rule of law. Bass describes a change in policy as one that emerged through a series of David against Goliath battles fought in the realm of public opinion, policymaking, and international diplomacy to become the most significant tribute that power has ever paid to reason. Bass seeks to do several things in his depiction of the Nuremberg Court as an unlikely hero of the post-war settlement. More significantly, he wants to cast criminal prosecutions as an astonishing achievement of universalist ideals which emerged through an epic struggle against numerous obstacles and wide-ranging opposition. Anti-impunity represents in this narrative the best of the American system's cosmopolitan promise. It is a humanist vision that perseveres against the forces of evil, but also against those with a lesser commitment to ensuring individual accountability for that evil, even when the victims are not one's own compatriots. However, if you step back from Bass's optimistic endorsement, the post-war moment looks slightly different. For instance, the London Charter, or the Charter of the International Military Tribunal, as it is officially titled, and to which Bass gives the Americans a central role in establishing. The London Charter details the mandate and procedures of the Nuremberg trials. It was signed by the Allies on August 8, 1945, sandwiched between the US bombing of Hiroshima on August 6th and Nagasaki on August 9th. The fact that these three events took place in the same week renders it less than persuasive that this was a choice of anti-impunity over impunity, of American liberal legalism over vengeance, or even, in the words of Robert Jackson, of reason over power. Rather, it suggests that anti-impunity and impunity are intricately related. There are many different ways in which to understand this relationship. Perhaps most prominent is a view that this linkage is a key to the notion of exceptionalism that fuels American empire, even where the notion of America as an imperial power is either denied or understood as benevolent when deployed in the service of democracy and liberty. More than any other country in Bass's story, the United States is a definitive liberal state advancing and embodying human rights ideals. These contradictions may not be dimensions of American empire, but may well be more central to liberalism and the world order in which it birthed. From the nation state and international law, from human rights and humanitarian reason. This dark side of virtue may be central to the foundational concepts of liberalism and their institutional embodiment. What is most relevant for the argument here is that anti-impunity reach of Nuremberg, and not to mention Tokyo, was carefully delimited. The London Charter not only sidestepped its brothers Hiroshima and Nagasaki, it also ignored a host of allegations about Allied war crimes that had taken place over the duration of the war. These crimes included civilian air raids such as the bombing of Dresden by British and Americans, wartime rapes by occupying Russian soldiers in Berlin, the killing of German prisoners of war in Dachau, and many more acts of torture, ill treatment, and killings of both civilians and enemy combatants. The narrative of Nuremberg as an ode to liberal global governance is an anthem to the post-war world order and its claim to universalist legitimacy. Perhaps this is why even the details of the trials are ignored by Bass. The institution of the court itself satisfies the anti-impunity project. It contributes to the endorsement of the position of the Allies as arbiters of a new world order in which their military victory is entrenched, not through the design of the Security Council, but also through the international financial institutions established in that period. Not only to the Security Council, I should say. The United Nations and the Security Council were established in October 1945. Only a few weeks later, in November 1945, the Nuremberg trials get underway. The next month, the International Monetary Fund was established, an institution that pushed structural adjustment and a plethora of policies that continued with the project that Susan Marks describes as planned misery. The momentous international institution building that took place in the last 3 months of 1945 is, of course, deeply linked. Elizabeth Bockwart has argued that Nuremberg, Bretton Woods, and the United Nations were the closely linked three-part institutional architecture designed to empower America in post-war global governance. Bockwart describes this brave new world as an achievement bringing to life the blueprint of the 1941 Atlantic Charter that expressed the United Kingdom and United States joint interests. In the Atlantic Charter, the Anglo-American alliance declared that after the final destruction of Nazi tyranny, it aimed to see established a peace which will afford assurances that all the men in all of the lands may live out their lives in freedom from fear and want, thereby employing various euphemisms which link the agenda of fighting the Nazis with the military and economic agendas of the Allies. The most significant implication of the story of these three post-war institutional projects resituates Nuremberg in the wider landscape of global governance in relation to both peace and security, as well as trade and political economy, legitimizing the dominant structures of global governance, with Nuremberg provided closure for World War II in ways that fed into redemptive history, endorsing the post-war settlement and the inauguration of what some might call the era of neocolonialism. This framing does enormous work as a redemptive narrative, celebrating liberal pieties and preemptively immunizing liberal states in mainstream narratives that seek to situate liberal states as pursuing a foreign policy that is in the interests of humanity. So this is the end of my sort of Gary Bass story, and I'm sort of going to wrap up soon. To sum up, when confronted with a crisis of legitimacy, scholars of international law and international relations, in my examples, Martinez and Bass, have repeatedly returned to a redemptive history of international law and institutions as a guide and inspiration to safer waters. I have argued instead that the legitimacy crisis is a prod, or should be a prod, to interrogate international legal history for its canonical biases, particularly with attention to the legacies of slavery, colonialism, and neocolonialism that are intertwined with international legal history. So let me conclude by situating my talk in relation to what Aimé Césaire, the Martinique poet of negritude, described as a boomerang effect. Today, in the bleak world we live in, many of us are preoccupied by the question of what does it mean and what does it require to resist authoritarianism. In answering that question, especially sitting here in the United States, I take seriously the reformulation provided by Nesiah in 1950 in one of the most poetic passages in Discourses on Colonialism, both mournful and sharply denunciatory. What does it mean and require to resist authoritarianism? This is what it is required. We must study, Nesiah says. We must study how colonialism works to decivilize the colonizer, to brutalize him in the true sense of the word, to degrade him, to awaken him to buried instincts, to covetousness, violence, race hatred, and moral relativism. What does it require to resist authoritarianism? This is what is required. We must show, Nesiah says, we must show that each time a head is cut off or an eye put out in Vietnam, and in France, they accept the fact. Each time a little girl is raped, and in France, they accept the fact. Each time a Madagascan is tortured, and in France, they accept the fact. Civilization acquires another dead weight. A universal regression takes place. A gangrene sets in. A cancer of infection begins to spread. And that at the end of all these treaties that have been violated, all these lies that have been propagated, all these punitive expeditions that have been tolerated, all these patriots who have been tortured, at the end of all the racial pride that has been encouraged, all the boastfulness that has been displayed, a poison has been distilled into the veins of Europe, and slowly but surely the continent proceeds towards savagery. And then one fine day, the bourgeoisie is awakened by a terrific boomerang effect. The Gestapos are busy, the prisons fill up, the torturers standing around the racks invent, refine, and discuss. This is what we must study. Vietnam, Madagascar, Algeria, Haiti, the Black Atlantic. This is the study that is required to resist authoritarianism. Thank you.
Mary Ellen.
Thank you, all three. I shouldn't go first, but I can. I just really learned a lot from all of your presentations, and I could ask several questions of each of you, but I'm going to restrain myself, as everyone sure wants to engage. So let me try to pick out two I want to start with, maybe a little time. Professor Nesiah, I've long been a critic of both Martinez and Bass. I have often said their narrow focus on human rights law without a wider context in international law, which has led to what I sometimes flaws in both of their analyses that you just described, so I thought well. But also embedded in your critique of the two colleagues is a general critique of international law. And so even if they knew a lot more, we would still be saddled with this very flawed system that is replicating a certain kind of authoritarianism large in the world. Do you think that international law is redeemable? If so, how? And if not, what are the prospects? And if I can ask Brad, Professor Roth, I think your main point, you worked up to it at the end, is that you are concerned about seeing the claim of sovereignty used against international law. And I thought Diana Nesiah described very well for us how authoritarian governments right now are using exactly what you described. But I'm really concerned that in leading up to that, you've created a straw man in the arguments that people use against sovereignty from within international law, that you're trying to defend sovereignty within international law, and that's not really the right way to get at this idea of sovereignty being used against international law. Aren't there more constructive ways than attacking international law or inviting this misuse by so, you know, of course, what I was saying during the debate, and I'm a little unclear on where you stood, because you started out by saying you're not under positivism, then but you didn't give us a broader idea of what you are in defense of. You seem to really only defend positivism. So I understand. I think your final point is important. I'm not following your path to get there. I would think a more grounded understanding of international law, educated, all of us would respond much more effectively without losing all the things that Karen Greenberg capitalists we absolutely have to have, not going to turn in on ourselves and take away what
At the risk of not being invited back, I think this violates Professor Desch's question mark at the end. The question,
No,
the
that was
question
the
is,
I think Professor Nesiah
Okay.
sees the question. I
All
think
right.
Professor Roth does.
all right, maybe you have to
We'll
be
see.
you have to be an international lawyer to understand that.
We'll judge by the answer.
Go ahead. I'm sorry. I'm being funny. That's all. Yes, I guess not very. Go ahead.
Yeah, so is international law redeemable? I don't think international law as a whole can be redeemed or condemned. However, I think it's all about, we don't have the luxury of giving up on using international law in particular struggles. Just like I think that, all of these, there's a, so in struggle after struggle, I think one needs to find, what Duncan Kennedy calls the gaps, conflicts, and ambiguities, to be able to see where we can use it against. And we see it in international law all the time. The people, it's constantly used against the grain, and it's often invoked in ways that that are not exactly what was anticipated. To give just one recent example, so in the Chagos Islands case with the International Court of Justice, the doctrine of ut possidetis, which was of course a classically colonial doctrine that was part of the Berlin Conference about respecting European colonial borders around Africa, gets used against the United Kingdom to defend the claims to advance the claims of Mauritius, in saying that Diego Garcia should be part of the Chagos Islands should be part of Mauritius and not the United Kingdom. So I think people use, that's our task. I think those who are critics of international law but nevertheless want to stay in the battle, is to be able to be creatively use international law, irrespective of what its what the larger arc of justice may be, because larger arc of international law may be, there is no arena in which we struggle where power is not relevant. So.
I thought that was a great answer to my question.
I agree. I agree.
Okay. Yeah. All right. So.
And
Hard to know where to start, actually, but I'm certainly not seeking to scapegoat anyone for the populist uprisings. It's not my point to say that the incursions of natural law and international law methodology has somehow led us to the unfortunate place we found ourselves. It is rather, though, to sort of warn against adding a certain kind of fuel to the fire. That states, I think, have an important interest in being bound only to what they have bound themselves to, and not to things beyond that on the ground, that somehow what they bound themselves to is merely a marker for a broader understanding of human rights derived from first principles or other kinds of consequences. I'm particularly concerned about the rhetoric of anti-impunity, and I could go off on that for a long time, but the real problem that I have with it, and the deployment of use Kogans to try to undermine ideas about immunity and ideas about nullum crimen sine lege, is that you end up elevating the idea of anti-impunity in a way that leads inexorably to the sense that the international law of peace and security that restrains empowered righteousness is degraded in the course of that. That if you have, it's a little bit like indicting Noriega as the justification for invading Panama. That we have to recognize that we are dealing in the world with people who we not without reason regard as criminals, and we need a framework of accommodation with those people. And so that sort of thing, I think, is an important problem to deal with. But I'm certainly not attacking international law, and I'm not attacking natural lawyers for having given us, Boris Johnson or Donald Trump or anybody like that, or Duterte, for God's sake. The thing about positivism is a very long discussion. What I would say about positivism, people hate positivism because what positivism says, among other things, is that an unjust law is law nonetheless. And I do adhere to that view. And so if you want to call me a positivist, I'm willing to take the bullet. But I also think that there is something foundationally wrong with positivism, and basically it's along the lines of the idea that positivism asserts that law is something that you find, and I think that law is something that you do. The project of applying old law to new facts necessarily involves an aspect of creativity that positivists are loath to concede, or positives seek to draw a clear line between what's legal reasoning on the one hand and what's policy judgment or moral reasoning on the other. And I think that that's a mistake, and that there are indeed certain fundamental aspects of legality per se that have some substance, because whatever the rule of law means, what it cannot be consistent with is arbitrary extemporary decree, as Locke would say. And so predictability and accountability of the international laws, predictability and accountability in the exercise of power are necessary orientations to anything that could properly be called law. I don't think it follows from that the kinds of substantive propositions that people want to impute to the project of legality necessarily are universal law, and so that's where I'm at odds with you, I think.
I have a question for Karen. I was very much involved with the Guantanamo detainee, the first request for precautionary measures came to the Inter-American Commission in March of 2002. And at that time, the position of the U.S. government was only international humanitarian law applies. We've never authorized you, the Commission, to apply IHL, therefore go away, which is kind of what you were saying Geneva 3 didn't apply. But recently, I mean, 2 points. One, in the famous organ failure memo, they look very hard at international law. They look at Ireland and the UK and say the European Commission said this was torture, the European Court said it wasn't torture, so therefore it's not torture because the court isn't the Commission. When in fact the European Court in Salmuni said, actually we changed our mind from what we said in Ireland and the UK, and nowadays it is torture. But they left that part out. But the point is, they did look at international human rights law. And recently, in 2017, the Working Group on Arbitrary Detention came out with a decision in the Al-Baluchi case, which was the continuing detainees. And they have a whole list of what international law was applied. That's under Trump. How do you understand this?
Yeah, so, okay, this is how I understand it, and I would welcome anybody's comments. Okay, this is going to sound really rude to the entourage of Bush lawyers that created these early documents, but I actually think that their ignorance about international law was profound, and that they incrementally were told by John Bellinger perhaps and others that, look, okay, you wrote that memo, but we need to consider this. And so then they begin to see, oh, there's different kinds of international law, and there's the laws of war. I'm not kidding. This is actually what I think would happen. Then, of course, when the so by August, you're already talking about a conversation that's morphed. You know, they've had to but I always think it was a Band-Aid. It was camouflage and cosmetic, and it was never something that they internalized and thought about. That's just what I think. Then when you get to now, the Bellucci case, you've already had the intervention of the Guantanamo, of the Obama attorneys. By the time the Obama attorneys, even though there are those of us who would criticize the way they bastardized international law in the name of the targeted killing policy, there was a new attention, particularly with Harold Coe, to focus on what international law was, and it became just something that they embraced and thought about and studied. And so it found its way. Then all of a sudden so by the time Trump comes around, there's no new set of lawyers that are working on these Guantanamo cases. Guantanamo has just literally by this administration been put aside. It's not. Do you see anybody?
Except for the trial
except for us, like we're paying attention, right? We're paying attention, we who follow Guantanamo, but in terms of you ask the, Trump administration, so list the issues that you think are important to deal with legally in terms of legal complexity and human rights. Guantanamo would not, it's not there. They might recognize issues of refugees. They might recognize issues of targeted killings that, things that they think they need to have an answer to. I don't even think they need to have that they weigh in on Guantanamo. Now I'm being, with a broader stroke and a little cynical, but the conversation has morphed due to the new lawyers that have come onto the scene. Now there is a recognition that they have to check off the box of international law, which you saw start to emerge with the August 2002 memos, Oregon failure. And then in Obama, it sort of comes into its own, but never in a way that's going to be dispositive or that is even in a balance with what we want to do policy-wise. So sorry, but thank you for that question.
My question is thank you very much for your addition. I thought it was quite refreshing looking at the colonial aspect of international law. And thank you for referring to Amy saying that woman I love very much. My question relates to the contestation rather over the concept of sovereignty in the international law realm, but also in the post-colonial world. Particularly looking at Africa, with the decolonization wave that began with Ghana in the 1960s and kind of flowing through the rest of the continent, we found the new emergence of a new domestic or African type of sovereignty, the nation state sovereignty that were very resistant to the prevailing international narrative, which is grounded in Western liberal thinking. And the likes of Nesiah and Frantz Fanon, etc. How does one then reconcile that context to the two? Particularly in recent times, you look at institutions like the ICC and how they've dealt with the international criminal law realm, impunity and issues of violations of the African continent, and how states have responded to that, asserting a very nationalistic sense of sovereignty. How does one then, particularly resolve or try to find a meeting point between these two narratives?
Oh, the dominant international law one and a post-colonial one?
Yes.
So I mean, my view on sovereignty is that, so I'm quite influenced by Anthony Ange's work that right from the beginning, even in the inauguration of the concept of sovereignty and when the Victoria and the Spanish jurists are looking at the notion of sovereignty at the moment of encounter, he argues that actually sovereignty gets invented in that moment, and it gets invented as one not about, it's not that, piece of Westphalia, we have it in the West and we're extending it to the rest, but rather it gets invented as a colonial project. So sovereignty has internal to it a hierarchy, right? So, to go back to Marianne's question, given the legacies of colonialism, you have limited avenues for how people can imagine and what are the institutional forms through which people can imagine emancipation. Sovereignty is advanced as one of them becomes soon the hegemonic form, but I think it's constantly important to remember both that sovereignty is often a trap, not just a goal. So it can, and I think for decolonization processes, it was both of those, and it lived that and the post-colonial histories of the global South is in some sense lives that contradiction, that it was the way institutional form through which anti-colonialism got channeled, but then was also became a sword against minorities and others internal to many countries, but also became a trap for those whose aspirations for emancipation were not captured by the notions of the notion of sovereignty. I mean, and the nation state. Within international law, the most important example, or one of the most interesting examples, of course, for the most longest durée, is the fate of the Sahabi people, who, the Western Sahara case now almost 50 years ago from 1975, a nomadic community that was forced into the boxes that international law provides and says, no, you have to think in terms of a territorial sovereignty when it's not, and other options for imagining, and you can think of that in a whole range of cases, Palestine, Kashmir, a whole range of cases when in fact people have complex lives that are not territorially bound, but nevertheless about by it. So that's one dimension of its limitations. I also think there may be, in some sense, the ways in which, so one of the arguments of many postcolonial theories is that political sovereignty became the trap for not focusing in that very first moment of emancipation itself on economic emancipation, right? So that you felt you had gained, you felt you had gained independence, but then in fact you go independence into a world order where the rules of the game were stacked against you. And so, what did sovereignty mean? So there's a way in which it channeled all of your energies into that. Not different, I think, from, I think there's a interesting parallel with the critique that critical race theorists apply in looking back to the disappointments of the civil rights movement. So when Derek Bell says, and we are not saved, it's about that the civil rights movement thought that law, the Civil Rights Act, desegregation, all of those Supreme Court victories would produce emancipation. And then, decades later, you still have, grinding racial inequality and in ways that are actually, in some contexts, not dissimilar to what you had in the 40s and 50s. So not that those were not achievements, it's like not that decolonization wasn't an achievement, those were achievements, but at the same time, we can also see the grammar there of the dystopic futures that would open up to as well. So.
Doug?
Karen, I want to save you from ending on such a pessimistic note. Good try. You told us that the lawless detentions at Guantanamo spread to the refugees at the border and now have spread to a U.S. citizen, I guess, in the pending case. And
Resident.
Sorry?
He's a resident, not a citizen.
A U.S. resident. Yeah. Permanent resident, I assume. And the implication was that once you let lawlessness in detentions out of the box, it inexorably, inevitably, and irreversibly spreads, and we're all doomed, and we're going to lock up John Mearsheimer before he gets back to Chicago. There are many examples in recent histories of countries that were in terrible human rights shape and got back on their feet in one way or another. Not that any country is perfect, but some countries in Eastern Europe, some countries in Latin America, South Africa, for example, problems in all of them, but nothing like what they had before. Do you not think it is possible that with a fresh election, I'm not talking necessarily about the next one, but at some future time, a new president and a new group of lawyers trained at Notre Dame, for example, will come in and say, by God, Mary Ellen was right. We're not going to lock people up without access to lawyers' charges, and we're not going to lock them up indefinitely. Are you suggesting that we've lost the battle? Or is there a window of hope and opportunity and challenge for Notre Dame law students in your remarks?
Okay, so of course there's an opportunity to turn it around, but it's been a long, slow slide, and it's gotten worse and worse. And look, they get habeas, but then the courts don't work to grant habeas for the Guantanamo detainees. So the Supreme Court passing a decision that literally gets ignored by the courts makes me worry. All right. The acceptance, sort of to your point, once you do it and you don't protest it, about France, what happens with a country that gets used to this? I think that too is a problem. And, you're asking the wrong person, because just to tell me why, because, lately, just to distract myself, I've been working on the Department of Justice historically. And the Department of Justice is not as strong as we might all like to think. Sort of like international law may not be as strong as we like to think. I mean, we're seeing visions of that now, so you don't have to be a rocket scientist. But I think the sooner the recreation of rights that are supposed to be guaranteed, the better. And I'll tell you where we should start. We should start with the people who aren't citizens, because what's happened is, and I'm, maybe revise that, but what's happened is, this project at the Century Foundation, I ended up doing the American context and just watching how, if you have all different distances from citizenship, from all different kinds of citizenship, and you look at how the laws stop applying to those at the furthest away from citizenship, right? And then they start applying to those whose, parents were born here, and then, more and more and more, and you start to see that basically what we've seen in this country is a move towards being able to take citizenship away from everyone. This denaturalization movement that's going on for convicted criminals and for others is serious. And so it lines up with our detention policy. So of course I'm the perpetual option. Sign me up for, to turn around, but it better be soon. That's really what I
All right, I'll answer that and say, no, I think it's too late already. And I mean that. But that doesn't mean there isn't a role for the young lawyers. But they better get with it right away, because there's not a lot of time. If we keep going down, and it's not gotten better, our national security policy from Bush to Obama to Trump has been very consistent. And it's leaning towards authoritarianism, in my opinion. And if you're going to look to the courts for any relief, look somewhere else, in my opinion. That's my experience. That doesn't mean that there isn't a great need for young lawyers to get out in the streets and do things politically and in individual cases. There's a tremendous need for representation of people in these denaturalization cases. I have several of them, for example, and I can't get any help on them, okay? Because you try to go to a big firm, the big firms can't touch them because it's too sensitive, because they're Muslims, that's why, which was a question I'd like to get at, but we don't have enough time. But there is a huge role for young lawyers if you don't decide that the only place you can practice law is big law. And I'll make that pitch to anybody else that says you can have this as a profession. If you treat it as a profession, you get a career like a professional. Treat it like a business, you're going to become a businessman. And I'm afraid that's part of the problem where the law has taken us. Big law has taken us down the wrong path, and big law is very responsible, in my opinion, for a lot of where we find ourselves. But that's a debate for another day. I want to give a round of applause to our panelists, but also to Mary Ellen and Bailey. This is a tremendous step.